Children and divorce. It's always a tough topic, but attorney Bud Klueck is with us. We've got some legal advice. He's going to show you how your children have input in your divorce process. So I guess we get right to that. How is that happen?
Well, they don't testify in court, Joe. Children generally do not testify in family court. Now, they do in juvenile court. Juvenile court involves juvenile delinquency, for example, where kids commit crimes, or juvenile dependency, where the kids perhaps are made wards of the state and put into the foster care system. But in family court, they really don't testify, and they can't even testify by declaration or affidavit on paper. So there are essentially three ways that kids have their input in family court. Two of them involve the court mediation process, which is called family court services. One is the obvious one. Family court services talks to the kids, and then they report to the judges what the kids had to say. And the ideal time, or the ideal age bracket, probably would be about 10 to 15 to be interviewed by family court services. If you have single digits kids, like 9 or younger, they're generally perceived as being too young or immature.
Right.
If you're talking about 16 and 17-year-old, particularly if they have their own driver's license, they're mostly focused on their peers. They're halfway out the door as it is. So 10 to 15 is probably the ideal age to have family court services talk to the children. The other way is that the kids have been involved in counseling, Joe, with a mental health professional or even school counseling. Family court services loves to talk to counselors because they themselves are mental health professionals, and they like to talk to other mental health professionals because they kind of walk the same walk and talk the same talk, and they've had similar educations. So those are two of the three. The other way is called minors counsel. That's an attorney appointed by the judge to represent the children. And we have done that many, many times. I'm thinking probably 3 figures by now, and many judges have appointed us. And it's kind of a labor of love, to be quite frank with you, because the county pays you, and the rate that they pay you is about 1/5 of what we usually make. But we do it because we care about kids.
Sure.
We've done it a lot. And that's a way that the children have a direct input. For example, Joe, we've had children or minors as old as 17 years, 364 days, and obviously when they become 18, they're out of the system. And similarly, I've had a child that I represented as young as 2 hours old. And yeah, we had a hearing. The dad showed up and said, "Mom gave birth yesterday." And so I told the judge that they were not in any position to go to court, and the judge appointed me. So I said, "This is a new Guinness World Record."
I guess.
The child is 2 hours old. They don't have a name yet, but they do have their own attorney.
Hey, Wednesday we talked about out-of-court methodology.
Yes.
All right. Does that enter in here as well?
Yes. If you want to ensure that your children will have input, then those other 3 ways, the out-of-court methodologies, Joe, work. For example, mediation, collaborative law, and cooperative law.
Right.
All of them have a component built into them that bring children's desires and fears to the table when things are being negotiated.
You know, I am glad that I am taping this show every day. I want to look back at this and learn something all the time, but you're always very interesting. I always great to have to learn these things that you don't know about, things that are available to you. Wow. You want to get in touch with Bud? You can call him at 619-448-6500 or go to his website. That is right there. You'll see it, familylawsandiego.com. All right? You can always go, of course, to fox6.com for more information. Thanks again, Bud.
Oh, you bet, Joe.
All right.